Negligence. Negligence is simply failure to exercise reasonable care under the circumstances. When I was still in law school, a classmate suffered a debilitating disease, making it extremely difficult for him to maintain his balance when walking. During the first day of our first year, I came up behind him in the hall after our first contract class, slapped him on the back to congratulate him for the masterful way he responded to our grouchy old professor, and was mortified to watch as he crumpled to the floor. He asked me only to help him get nearer the wall, where he managed to pull himself erect again by working against the vertical surface until he was standing on his own like the rest of us. He waved off my anxious apologies, and we became good friends afterwards. However, I never forgot the lesson. I had no idea my good-natured congratulations slap that would have no effect on an otherwise healthy person would cause my friend to collapse. Nonetheless, I was negligent and legally responsible for the consequences of my actions. It doesn't matter if the defendant intends to harm the plaintiff. If his acts cause harm, as mine in slapping my classmate on the back, the defendant is liable for injuries that directly result from his act. The common law adage, a defendant takes his plaintiff as he finds him, applies in all cases and should cause us to exercise a greater degree of caution to protect others from the consequences of our negligent acts. Now, Mr. Anonymous says this to me all the time. When he was in law school, it really changed his mindset on how he viewed things. He looks at everything as a liability. Everything is a liability, Derek. Be careful what you say. Be careful who you interact with. Be careful who you bring to your home. It would be very wise if you have people that come over to your home. They have a little directory that they get to sign in and sign out of. So you know what time they were there, when they left, a release of liability form. He's very adamant about all this, and for good reason and for good cause, right? So everything that he encounters in his life after going through law school, he tells me he calculates and mitigates the risk of liability based upon a certain amount of elements, and he can mitigate the risk to such a degree that minimizes any liability he may carry in the future. So when you're interacting with people, always think about the liability. You are responsible for damages caused by what you do, even when the person damaged was unusually susceptible to injury. This is known as the eggshell skull doctrine, a principle that arose in a case where a man with an unusually thin skull was seriously injured by an accidental blow to the head, so slight that it could not have caused a healthy man so much as a headache. Nonetheless, the act resulted in harm, and the actor was liable. Each of us owes all others a duty to act with care. Failure to carry out this duty in a responsible manner is the essence of a cause of action for negligence. Elements. In order to effectively plead a cause of action in negligence, the plaintiff must allege sufficient ultimate facts to show each of the following essential elements exists. 1. Defendant owed plaintiff a legal duty to exercise at least reasonable care, or in some case to conform to a higher standard of care. 2. Defendant breached his duty of care. And 3. Plaintiff was damaged as a direct result of the breach. It's no more complicated than that. Defense. Comparative negligence. In many cases, the plaintiff is at least partially responsible for his own damages. Where this is true, the plaintiff cannot recover that portion of damages caused by him. He is said to be comparatively negligent. Therefore, if the plaintiff ran a stop sign and was hit by the defendant's car going 120 miles an hour, both parties are somewhat responsible. Plaintiff for running the stop sign, defendant for speeding. The jury will determine the degree of their comparative negligence and apply this as a percentage to determine that amount of harm caused by the defendant only. Economic loss rule. The following explanation from the economic loss rule prevents plaintiff from double dipping. Many times plaintiffs file an action for breach of contract and also for negligence in performance of the contract. The economic loss rule prevents plaintiffs from collecting for both. For example, a case involving a contract between a strawberry farmer and a chemical company was filed in Florida when a batch of fertilizer the farmer ordered turned out instead to contain herbicides that killed all of his strawberry plants. The farmer's case had a count for breach of contract and another count for negligence. Since the farmer contracted for the fertilizer and received herbicides instead, he sued for breach of contract. Since the packaging of the herbicide in fertilizer bags could only result from boneheaded negligence, the farmer also sued for negligence damages. The farmer won, and the economic loss rule did not apply. In another case, however, a farmer sued a tractor manufacturer for breach of contract and negligence when a negligently designed part of the tractor caused the tractor to fail, and the farmer couldn't get his crops in on time. The faulty tractor resulted from negligence. The court said in this case, however, that the bargained for consideration was a tractor, not crops safely gathered into the barn. When the tractor failed to work, it was only the tractor that was damaged by the defendant's negligence. The farmer's contract for a working tractor was breached by delivery of a faulty tractor, and the farmer won on his breach of contract count. The tractor did not directly damage the farmer's crops, however, so the farmer was not permitted to recover for negligence. Since the damages were not to property other than property the farmer contracted for, a working tractor, the courts restricted his recovery to breach of contract and denied the negligence count. The economic loss rule barred his recovery for lost crops. In the first case, a negligently delivered chemical damaged other property, and the economic loss rule did not prevent recovery for both breach of contract and negligent damages. In the second case, a negligently manufactured tractor damaged itself, and the court applied the economic loss rule to bar the farmer from recovery of his negligence count for crops left to rot in the field. The idea of the economic loss rule is that when one is prevented from enjoying the benefit of the contract bargain by negligence that only affects the things bargained for, recovery must be by a breach of contract action alone. The negligence count will not be heard unless the defective thing bargained for also damaged other property. You cannot double dip, since the negligently manufactured tractor damaged only itself and not the farmer's crops. The farmer was required to seek recovery in court solely on his breach of contract count. When the negligently packed herbicide destroyed fields of strawberries, however, the farmer was permitted to recover damages both for breach of his contract he paid for the fertilizer and for the negligent delivery of the herbicides that destroyed his crop. The economic loss rule applies to restrict recovery only to a contract count when negligence damages the thing bargained for. In such cases, the injured party is said to have lost only the economic value of his bargain. If the injured party also suffered damages to other property, however, the economic loss rule does not apply. Both contract and negligence law may be used to get a judgment for damages if something other than the bargained for thing is damaged by the defendant's negligence. Assumption of risk. Some activities, ergo karate and skydiving, are so inherently dangerous that the courts will allow a defense against plaintiffs who voluntarily engage in such activities. If plaintiffs expressly assume the risk of a bodily contact sport like soccer or football, the courts deem that he has waived his right to recover damages for injuries resulting from contracts inherent in the sport. The plaintiff need not sign a paper acknowledging the risk, though, of course, this creates an even stronger defense. If the court can infer from facts presented that he understood the severity or foreseeable consequences he was risking and proceeded to practice without regard for the risk, this defense does not exist. However, where the defendant was wantonly or recklessly negligent, thus exposing plaintiff to risk that was not foreseeable, ergo the parachute club that packed old rags in a parachute bag. Quantum merit, it's Quantum meruit. A cause of action of quantum merit arises when one person confers a benefit on another under circumstances that would cause a reasonable person to believe he would be compensated by the other. The Latin phrase means literally for so much as the thing is worth. See unjust enrichment. Promissory note. This is perhaps the easiest of all lawsuits to win. Plaintiff's possession of a signed but unsatisfied promissory note raises presumptions of non-payment and shifts the burden of proof to the defendant to show he paid the note in full, on time, with interest. This can only be shown by receipt, canceled check, or other evidence of actual payment. If the defendant cannot prove he paid and satisfied the note, the court will grant judgment for the portion of the note that remains unpaid, together with accrued interest thereon. If the note also provides in its terms for judgment of a reasonable attorney's fee and cost, the plaintiff recovers judgment for the full amount he is owed plus the cost of bringing the suit. Elements. The elements are simple, common sense. 1. Defendant executed and delivered a promissory note on a certain date. 2. Plaintiff owns and holds the note. Owns and holds the note. Owns and holds the note. Means they can present the original instrument, okay? This is what the bankers are getting away with. They're getting away with bloody fucking murder. A copy of the original note is usually required to be filed with the complaint, and the original note will be required to be produced at trial unless the court allows the plaintiff to establish its existence another way. 3. Defendant failed to pay some part or all of the note when payment was due. And 4. Defendant owes plaintiff a certain sum based on terms of the promissory note. Now, promissory notes. Very interesting thing here. Through a great amount of due diligence, I have discovered that you will never see a promissory note that says that you must pay it back in Federal Reserve notes, okay? What is implied, what is inferred, all that goobly-gop doesn't fucking matter because the law is specific. So, if you go back through your promissory note and it says, I promise to pay, and it gives you one of these fancy little symbols with a numeric value behind it, but you don't know what that symbol is, you presume and assume you know what it is. The truth of the matter is it's vague and ambiguous, and you can't be compelled to fulfill an impossibility, all right? Now, some people go, oh, Derek, well, that's immoral, that's unconscious, what you're doing. You knew what you were doing when you were doing it. That is not the fucking point. The point here is, if you're going to put that kind of, if you're going to ostracize people with that kind of mindset, understand this. The bankers are the biggest motherfucking criminals the world has ever seen. Lord Mayor Rothschild said, I care not who makes the motherfucking laws, people, so long as I control the money, so long as I create the currency, I don't give a fuck who makes the laws. All right? That's how powerful that is. So before you start ostracizing people because they're like, hey, you know, that promissory note isn't very specific, it's a void instrument, you know, the bank actually created it, they bear the burden because they created it, their lawyers dreamed it up, drew it up, and it was vague and ambiguous and not specific, and they've created an impossibility, and therefore there is no debt due and owing. Plus, they don't hold the original note. The mortgage is not in arrears. There never was a loan, and the bank refuses to produce the 1098. All right. Where many plaintiffs get into trouble with acceleration of the note, i.e., they may attempt to bring suit when only one payment is late, in which case they can only recover judgment for the amount that is then due. If the note itself does not contain a provision that the full amount will become due at once and payable upon the event of any default, i.e. an acceleration clause, the full amount of the note will not be due, nor the plaintiff have a cause of action to collect until full term of the note has run. Always make sure you put an acceleration clause or a clause for attorney's fees and costs in any promissory note you accept from others. Defense. Payment of a promissory note is, of course, an absolute defense. To prevail, the defendant need only tender the court admissible evidence to demonstrate that all funds payable under the term of the note, including interest, have been fully paid. Another absolute defense arises where the holder of the note has negotiated some consideration for the note other than payment. Either way, the obligation to pay disappears, and along with it, the cause of action. Replevin. A cause of action for replevin seeks a court order directing the defendant to return possession of specific goods, furniture, equipment, or other such personal property, not money or real property, to the plaintiff. Elements. The complaint must contain the following: description of the claimed property sufficient to identify it and its location, if known. 2, the property's value supported by bills of sale or similar evidence, if available. 3, a statement the plaintiff lawfully owns the property and is entitled to possession. 4, a statement that defendant is wrongfully in possession of the property, how defendant came into possession, if known, and why defendant is wrongfully detaining the property, if known. 5, a statement that the property has not been taken for a tax assessment or fine pursuant to the law. And 6, a statement of other damages suffered by the plaintiff as a result of defendant's wrongful retention of plaintiff's property. Remember, possession is 9/10 of the law, but what people never capitalize on is the other 10th, and it's the most important 10th. Okay, that 1/10 supersedes the 9/10, and that's title. So stop arguing around title and start arguing through title. Okay. A successful replevin action results in the court's issuance of a right of replevin directing the sheriff to take possession of the property and turn it over to the plaintiff, who may be required to first post a bond and pay the sheriff some reasonable fee for his troubles. When we come back, we're going to talk about rescissions, okay? Rescissions. Thanks for joining me. Thanks for all your support. When we come back, we'll be talking about rescission of signature, rescission of contract.